Mr. Haney.
Good morning, Your Honor.
Good morning, counsel.
Good morning, Your Honor.
I understand you guys are here. I want to let you know that I knew you were here, but I have a couple of other things that I want to do before I get into your motion, because that's obviously going to take us quite a bit of time. So I'll put you back in the waiting room.
Thank you.
Thank you.
I've got Thurnblad here too. I will tell him too. You guys haven't resolved this matter, have you?
We have not.
We have not.
Okay, that's all I need to know.
All right.
That's what they pay me for. You know, like I tell people all the time, they don't pay me. Mr. Thurnblad? Good morning.
Yes, sir.
I've got all three of you guys here on the auto owners matter, but I've got a number of other things I'm going to do before I get to you. In the meantime, you guys can always resolve your file. If not, I'll make my decision today. That's why I get paid. They don't pay me to be perfect. They pay me to make a call. The only people who get paid to be perfect in this system live in a palace of marble in Lansing. I work in a warehouse in Detroit. I'll get to you guys as soon as I can.
Thank you.
Thank you.
Thank you, Your Honor.
Rules and steps. Good morning.
Morning, Judge. How are you today?
You're not bad for Monday. How about yourself?
Well, not bad. I opened up the court at 8:02 down at the clerk's office, that special time of year.
Oh, yeah. Let's get started. This is file number 23-145-359. LVNV funding versus Erica Steps. This appears to be our third pretrial. Your appearance.
Judge, may it please the court, my name is Attorney Richard Gruson. My bar number is 35222. I'm the attorney of record for the plaintiff, and I am the attorney appearing today on behalf of the plaintiff.
And what is your name, ma'am?
My name is Erica Steps.
Okay. How are we doing on our written discovery? Are we done?
I am
Still-
done for my purposes, Judge. I served defendant by first-class mail copies of requests for admissions, interrogatories, and a production of document requests on May 25. We are now on the record on July 10th. The discovery is overdue, and frankly, I'm in the position now to file a pretrial motion for summary disposition. That I rest.
Ms. Steps, are you done with your written discovery, or do you planning on doing any?
A written discovery, I sent my response back, but a written discovery, I don't have anything to send because I'm just waiting on a contract with my signature on it.
Okay. Then what I'm going to do, if nobody has any more written discovery, your written discovery is closed. I'll give you the next pretrial date. That will be August 7th at 10 o'clock. We'll send
Okay.
you out of order. Anything else we can accomplish today?
This time, plan for us, Judge.
Mr. Riddell,
Good morning, Your Honor. How are you?
I'm good. Yourself?
I'm good.
What do you have?
I have LVNV versus Helen Long. This
Okay.
case-
I think I have Mr. Kirschenheiter here on that one. Let's
Okay, that sounds right.
see if that's gonna be right. I got him on two cases apparently. Mr. Kirschenheiter,
Hi, Judge. How are you?
I'm not bad for Monday. Yourself?
Not too bad.
What you got?
I got two.
You got LVNV funding versus Helen Long?
I do with Mr. Riddle.
Let's do that. And I got him here. We are on the record calling file number 23-146-967. LVNV funding versus Helen Long. This is our second pretrial. Could I have your appearance?
Yes, good morning, Honor. Michael Kirschenheiter for the plaintiff, P75722.
Good morning, Your Honor. Sean Riddell, P81302, appearing on behalf of defendant Helen Long.
Gentlemen, how is our written discovery coming?
I
Your
don't.
Honor,
Yeah, go ahead, Mr. Riddle. Go ahead.
I haven't served any written discovery yet. Plaintiff's counsel has served over what would be essentially initial disclosures. We are working on an issue that I haven't had a an opportunity to talk to Mr. Kirschenheiter about that may end up with cross motions for summary disposition. I believe their motion is scheduled for August 9th, and I think we would be okay with filing a motion to be heard on that date as well.
Okay, well, I have no motion for summary disposition scheduled.
Okay,
The court schedules its own motions.
right.
So what I had you guys down for my next pretrial date is August 7th. Is
That works for me as
is that gonna
well.
wait for both of you for your motions, or do you want another time?
Well, if it's up to Mr. Riddle, we filed ours, so we can have it heard whenever the court would like. But if you're filing something, Sean, if you need time, it's up to you guys.
You know what, actually, I'm wondering if after your second hearing, maybe we could step into a Zoom room and talk about the issue for a sec. But I think that the 7th would work with enough time for me to get a motion filed. And
All
tell
right,
you,
then what I will do is I will close your written discovery. I will calendar for August 7th at 10 o'clock, cross motions for summary disposition. Okay,
perfect. Thank
right
you.
now, Mr. Kirschenheiter, what is your other case?
It is 278
And that's, who's the defendant on that?
Ralph Sewell.
I don't have Sewell as of yet. So what I'm going to do is I'm going to put you guys into the chat room. You can have your conversation. August 7th at 10 o'clock will be your cross motions for summary disposition.
Thanks, Judge.
Let's see.
Thank-
Mr. Rusin, are you covering Mr. Varketti's motion to reopen case?
Yes, Judge, I am.
All right, I have her here. 354. Good morning.
Good morning, Your Honor.
We are on the record calling file number 23146-354 LVNV Funding versus Deborah Copeland. Date and time for plaintiff's motion to reinstate the case. Your appearances.
Judge, may it please court, my name is Attorney Richard Rusin. I am one of the attorneys for the plaintiff, attorney of record, and my bar number is 35222. Today, I'm also on your docket as the petitioner and plaintiff's motion to reinstate this civil action.
And what is your name, ma'am?
Deborah Copeland.
Ms. Copeland, did you file an answer to this motion to reinstate the case?
No, I did not.
Mr. Rusin, your motion.
Judge, may it please court, I'm going to waive oral argument and rest on my motion. And so I will rest on that. And because it appears to be an uncontested motion under MCR 2.119, I would ask that you grant the motion to reinstate the case and move the case forward. On that, I rest.
All right. No apposition having been filed in this matter, the motion to reinstate the case will be granted. The file will be set for pretrial August 7th at 10 o'clock. Your written discussion. All right. We are on the record. This is file number 22-192503, Auto Owners Insurance. The defendants are Rescue Unit Towing, Drake's Collision. We have a motion for summary disposition filed on behalf of Rescue Unit Towing. Appearances.
Morning, Your Honor. Jared and Jeske on behalf of the plaintiff, P77599.
And good morning, Your Honor. Steve Haney on behalf of Drake's Collision, P63947.
And good morning, Your Honor. Kurt Thornblade, 25858 on behalf of Rescue Unit Towing.
Mr. Thornblade, your motion.
Thank you, Your Honor. The factual involvement of my client in this case is my client was asked to do a tow at an accident site
By the police or someone else?
by the owner.
The owner of the vehicle?
Yes, the owner of the vehicle. The police arrived later after my client had, and the owner of the vehicle informed my client that he had insurance, and the car had to be removed from the location. Because of the time, my client was not able to take it to Drake's Collision because it doesn't take cars at night. My client has its own yard where it could protect it over the night, so there were two tows involved. My client took the vehicle to Drake's Collision.
Now, how did it get to Drake's Collision? I didn't get that part.
Drake's Collision was the owner said, "Do you recommend a place?" And my client driver indicated, "Well, Drake's Collision," and the owner said, "That's fine."
Okay, move on.
My client then had to store the car overnight, so my client was involved in 2 tows. My client gave the bill for the tow to Drake's Collision. They went ahead and paid my client directly, and then forwarded the bill as part of their general bill for repairs and services in this case. There are 10 different causes of action that have been pled by the plaintiff, and we asked the court to have a look at these. Court could, on our arguments, either deny our motion for a summary disposition on that particular count, could make a decision on all or some. Either would be welcome in view of the complexity that the plaintiff has inserted into this case. Counts 1 and 2 both involved conversion. Conversion has elements, and the elements are you have to take property that belongs to another, convert it to your own use. My client was under instructions from the owner of the vehicle, take my vehicle, take it to Drake's Collision. At no time did my client exercise anything more than the permission that it had been given by the owner with regard to the vehicle, and ended up surrendering the vehicle and the keys to Drake's Collision. Count 3, plaintiff says that fees are set by the motor vehicle code with regard to tows, and that is not quite correct. In the case of a police tow under contract to a police agency, there are set fees. The law in this state is that in the case of a private party tow, the fee can be whatever is set. There's nothing in the insurance contract or or anything else that just controls the fee. Counts 4, 5, and 6 all involve fraud. Fraud depends upon a misrepresentation of fact. No one associated with my client has misrepresented any fact. Now, you may say that the towing charge was too high. Perhaps there is some remedy for that in the law, but basically, when somebody performs a service, in the absence of a direct agreement as to the fee, you can ask whatever you want and argue it later. In this case, my client has already been paid, so he's out of the picture. Count 7 is
Let's stop right here,
unjust.
counsel.
Yes, Your Honor.
Let's break this marathon up. Let's hear from plaintiff in regard to counts 1 and 2, common law conversion and statutory conversion.
Your Honor, there's a question of fact as to that issue, whether or not there was permission pursuant to the affidavit attached to our motion. Our
The
insured did not.
affidavit came from your adjuster.
Correct, Your Honor.
I did not see the affidavit from the driver. Did I miss that?
You deny, Your Honor.
All right. The court is going to grant motion for summary disposition as to counts 1 and 2, statutory and common law conversion. Moving on, sir, your response to count 3, the alleged violation of MCLA 257, 252. Plaintiff, it's your turn.
Sorry, Your
Remember,
Honor.
I'm breaking them up.
Yeah, my bad. As far as that one, Your Honor, that statute states that when there is a police tow, the has to be reasonable towing and storage fees. Here, I attached the call log that this was a police tow. Police arrived on the scene, and it falls under that purview. I've pled all the applicable elements of that claim, so it survives a C8 motion. And there's dispute on whether or not this was an actual police tow, and therefore there's a question of fact defeating it pursuant to MCR 2.116C10.
Yeah. Counsel, your response to that?
No, Your Honor, it was a private contract between the driver and the owner of the vehicle and rescue unit towing.
Did I miss the affidavit in that regard?
Yes, Your Honor, that is the affidavit of my client attached
That's
to
the affidavit of whom?
The affidavit is David Avery, who is the owner and president of
Was
Rescue.
not at the scene.
Yes, he was. He's also the driver.
He was a driver of the tow vehicle.
Right, and he's also the president of the company.
Okay. I'm gonna find that there is a question of fact in regard to count number 3, the motion for summary disposition, as to count 3 is denied. Next count, we're gonna hear from plaintiff in response to is count 4 and count 5, fraudulent and innocent misrepresentation.
Your Honor, that also spawns out of the fact that the insured was under the understanding that it was a police tow.
Excuse me, the insured was of the understanding, or someone made a representation. But a common element in both of these is that a representation is made. At the time the representation is made, it is made and it is false at the time. Your client's understanding is not the equivalent of a representation.
Correct, Your Honor. And I guess I'm clarifying it's more as to the silent fraud count where information regarding that they were connected to the police should be disclosed and therefore not.
And
failure.
that silent fraud requires an affirmative duty to disclose. What is the basis of this affirmative duty to disclose?
Your Honor, would be based on the fact that the tow truck driver was
I'm
holding.
asking for a legal basis.
Okay. Your Honor, I did not, I will concede that I did not cite to that in my motion.
All right, counts 4 and 5, fraudulent misrepresentation, innocent misrepresentation, motion for summary disposition is granted.
And
That would leave count 6, Your Honor, which is the silent fraud.
Whoops, I miscounted that. 4 is fraudulent misrepresentation. 5 is innocent misrepresentation.
6 is silent fraud.
6 is silent fraud, and your argument on that?
There's no
No,
duty.
no, not you.
Oh, sorry, Your Honor.
and Your Honor, if I may just, yeah.
Well, I'm so used to being in the frying pan that I have to stay on the stove.
Let me hear from plaintiff on silent fraud.
Your Honor, yeah, I just previously
Yeah.
spoke on that. As a silent fraud, I understand that. And just for the record, I'm not asking the court to change their ruling to the fraud issue, but just for the record, the misrepresentations was that these fees were actually incurred, such as the cleanup of the accident scene itself, when the dash cam video shows it wasn't performed by the defendant. But I understand the court's ruling.
Okay, so we're down through 6. We are now going to hear argument in regard, beginning with count 7 from our moving party, Mr. Thornblake.
Your Honor, with regard to
That one is
unjust,
in regard to the plaintiff's claim for enrichment, not enrichment.
yes, Your Honor. Well, my argument with unjust enrichment is all the authorities said it's an equitable cause of action and the district court lacks equitable jurisdiction.
Counsel,
Your Honor, when it's well, unjust enrichment can be based solely on equitable jurisdiction, but also when you're seeking to enforce a contract pursuant for a money judgment, therefore that isn't within the purview of the district court.
there is no written contract here, is there? Did I miss it?
There is no written contract. It would just be an implied contract.
This is a strictly equitable request. I just lack subject matter jurisdiction here. The court finds that in regard to count number 7, unjust enrichment, I have no subject matter jurisdiction. The next the next count is violation of the Michigan Consumer Protection Act, which would be count 8. Mr. Thornblake.
Yes, Your Honor, the Michigan Consumer Protection Act does not apply between commercial parties. And that's pretty well established. And Paul versus Global Neurological Associates, it's a similar case in which an insurance company sought to assert the Michigan Consumer Protection Act in a transaction where maybe the consumer would have had a claim for under the Consumer Protection Act under statutes relating to medical release. And the Court of Appeals tells us, well, that's not the kind of transaction that's anticipated under the Michigan Consumer Protection Act. So it's the same thing. Insurance company duty to protect protect an insured against injury is not between the consumer and the person performing the service. It's between the insurance company and the person performing the service.
I'll hear from plaintiff.
Your Honor, since it's plaintiff's insured, she's an individual and therefore it's not two businesses having a transaction. The transaction was between Ms. May Doyle and Rescue Unit Towing. Therefore, it is for personal use, and so this vehicle was insured for personal use. Therefore, it doesn't fall under the case cited of the Paul Glendale Neurological Association, where that was a business asking and completing a transaction.
Anything else, Mr. Thornblake?
Well, the party that Mr. Andrzejewski refers to is not a party to this case. The plaintiff is the insurance company, not the owner of the vehicle.
Well, I think that I'm prepared to rule on that, and my ruling is going to be based on a slightly different ground than you gentlemen are arguing. The Michigan Consumer Protection Act doesn't regulate all interactions with consumers. The case law is quite clear that where the legislature has chosen to regulate that industry, that the Michigan Consumer Protection Act doesn't apply. An example would be, for example, insurance companies. Here, as we know under MCLA 257-252, that is the police towing casualty, although the legislature has spoken not to all aspects of the towing business, it has spoken on the towing business and has chosen to regulate only police tolls. So the court is going to say that we have an area where the legislature has regulated, but has chosen for whatever reason not to regulate the amount of police tolls, but that shows that there has been regulation by the state. This is not a preemption issue where the question is whether or not the action of the state fills the field. The question here is whether or not the state has elected to legislate and regulate this industry. If so, it's not falling under the Michigan Consumer Protection Act. The motion for summary disposition for count 8, violation of the Michigan Consumer Protection Act, is granted. Count 9, civil conspiracy.
Your Honor, a civil conspiracy has to be an agreement between two or more parties to do an illegal or antisocial thing. The only agreement that can be shown here is that whenever the towing company takes a vehicle to the tow yard and the tow yard says, I'll pay your bill for you if you hand it to me and I'll send it into the insurance company, is not illegal, and it's commonly done every day.
Counsel.
Your Honor, based on the prior court's rulings, as far as the fraud and conversion, since those are dismissed, those can't form the basis of a conspiracy because there's no underlying tort. And then we're down to whether or not the charging of unreasonable towing and storage fees would be a tort under this that would provide a basis for the conspiracy. It's our position that there is sufficient to form a civil conspiracy as to that count. But majority of my brief was focused on the part of conversion, which has been dismissed.
Well, the biggest problem that I have with civil conspiracy is an agreement to do a lawful thing in an unlawful way, or an agreement to do an unlawful thing and steps in that in furtherance of that agreement. I'm not seeing the unlawful agreement here. You're presuming the fact to be you bootstrapping. You're saying because I don't like to charge, it is unlawful, and therefore that makes a civil conspiracy. There's no indication here in this record, now maybe you have it from somewhere else, that there's a deal between the tow yard and the towing rescue unit. Hey, why don't you bring me tows and I'll go ahead and I'll kite up my bill and pass it on to the insurance company. That may be what you believe is happening, but there's no support for that in the record. So the court is going to grant summary disposition in regard to count 9, the civil conspiracy, which leaves us count 10, which I'm going to do without going any further. I don't have jurisdiction for declaratory relief.
And I can see that, Your Honor. I put that in my response, so that's no issue.
So let me go over in summary the ruling of the court. Counts 7 and 8 are dismissed without prejudice for the reason that the court lacks subject matter jurisdiction. The motion for summary disposition is granted as to count 1, count 2, count 4, count 5, count 6, count 8, count 9. Mr. Thornblade, I'll be looking for the order under the 7-day rule. Mr.
Thank you, Your Honor.
Nice
I'll
time.
submit. I
Nice
think,
time.
count 10, I think you're dismissing without prejudice for lack of jurisdiction.
Yeah, 7 and 10 are no jurisdiction. I don't,
7 and 10.
there's no subject matter jurisdiction here. I can't do equitable things. I can't do declaratory judgments.
Okay, thank you.
Your Honor, we concurred and joined on the 22nd of May. I just wanted to make that record clear and let the court know that.
Well, I am aware that you joined in Mr. Thornblade's motion, but since his motion was about his client, what I took your motion to say is, I agree with the things Mr. Thornblade has said as to rescue towing. There was nothing that was other than your joinder that said, this is what's different, or this is what's applicable in regard to my client, the tow yard. So if you want to file something in regard to that, I'll deal with it if and when it's filed. But all I took your joinder was, I agree with Mr. Thornblad in his claims as to his client only, because there were no claims made in his motion as to your client. Likewise, the answers made by the plaintiff, which spoke to the towing company and not to the towing company and the tow yard. So if that's where we are. So basically what's happening here now is we have two lawsuits, or two defendants. Mr. Thornblad's client has one claim left. Your client has 10 claims left. I would presume that from my ruling, you and counsel for plaintiff could be able to work out some of the claims that remain against your client. If not,
I would stipulate to the conspiracy, Your Honor, because you can't have a conspiracy with one party. So I'll
kind of
stipulate
hard.
to dismissal of that. So
I was going to make that point, but
So you guys get that together. So what's going to happen?
well.
I'm going to get two orders here. I'm going to get a order between by plaintiff and the moving party in regard to the towing. I'm going to get a stipulated order between plaintiff and the towing storage facility as to them. Now, I'm not, for example, going to see how I'm ever going to have subject matter jurisdiction in count 7 and 10, regardless of whom the defendant is. So let it be written, so let it be done. We will next be together August 7th at 10 a.m. And now
Thank you, Your Honor.
that we have narrowed, at least in part, the field, we have to decide, and again, this is a business dispute. We're not curing cancer or feeding hungry children. Whether it's time to resolve this matter or you wish to continue to kill more trees. I'll see you guys August 7th at 10 o'clock. Looking forward to your two orders by stipulation in regard to the tow yard under the 7-day rule, if you can't work it out in regard to the towing company. Anything else, gentlemen?
No, Your Honor, thank you.
One quick thing, Your Honor, may I have 7 days to perhaps kill another tree to file my motion?
I'm not limiting you. If you want to file your motion, you just make sure you do it before the next time we are together. So then I'll be able to calendar that too.
Thank you, Your Honor.
Okay?
Thank you.
Anything else?
Yep. Not from plaintiff, Your Honor.
Now, I must say that this is one of the cases where I'm at a disadvantage because we are virtual rather than in person. Were we in person, I would invite you three gentlemen to the bench, grab an ear in one hand, an ear in the other hand, and bang heads until the case was resolved. Kind of hard to do on video screen. So we'll see you guys August 7th at 10 o'clock. Thank you for coming in.
Thank you.
Thank you, Your Honor. Have a
Have
good
a
day.
good day. We are on the record calling file number 23-146-278, Portfolio Recovery Associates versus Ralph Sewell. This is matter scheduled for a pretrial today at 10 o'clock. We were last together on this file on June 14th, 2023, at which time the parties in the court agreed to today's date, July 10th at 10 o'clock for our next pretrial. It's now after 10:30. The defendant has failed to appear. Could I have your appearance, sir?
Yes, good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722.
Mr. Kirschenheiter, you were not nice. Is that what it is? The guy didn't come?
I guess not. With defendant failing to appear, Your Honor, we would ask that the default enter.
Default will enter against the defendant who has failed to appear. No good cause having been shown.
Thank you, Your Honor.
Good morning, Your Honor.
Morning. We are on the record. This is file number 22-178-276, Dearborn Total Automotive versus Olivia Martin. This is the date and time set. Whoops, wrong file. This is the date and time. Here. Set for pretrial by a notice dated June 14th, 2023, which was the last time that we were together. On that date, the court entered an order adjourning the plaintiff's motion for summary disposition, which was scheduled for July 10th. So, Mr. Cole, could I have your appearance?
May it please this court, Leslie Cohn appearing on behalf of the defendant, Olivia Martin.
All right, have you guys settled the case? What's going on here?
No, we still have to talk, Your Honor. We have not settled the case.
All right, then I'll have to set the date for a hearing on the motion of summary disposition there.
All right, we'll presumably resolve it before then, but I would love to have been able to speak to my opposing counsel today.
Well, you know, you guys, I have been holding your hands and letting this case slow walk since its inception.
I
Okay,
agree, Your Honor. I've stipulated to setting aside defaults 3 or 4 times.
he set aside a couple of defaults. He stipulated there have been a couple of instances where dispositive motions were adjourned. So, you know, you guys are just really, the fault is my own. I should not have permitted this. And I thank you for the lesson. I will not repeat this mistake again. I will set for August 7th, the motion for summary disposition at 10 o'clock. If you want to file a responsive pleading, sir, you should get started on that right away.
I will.